I Student. I Student is a platform for law students to come here and deliver a lecture on the topic of their choice. Today we have with us Swinal Ghadi. She is going to deliver a lecture on Transgenders Employment Reservation in the state of Maharashtra. She is from KES Shri Jayantilal H. Patel College of Law. So without wasting further time, I would call Swinal Ghadi to deliver a lecture. Thank you.
Today, I shall be speaking about the ongoing quest of the transgender community to seek reservation in public employment in the state of Maharashtra. Now, speaking from academic perspective, this is the subject matter of administrative law, and administrative law holds great significance in India as it is the backbone of the nation's governance structure, as it provides a platform to the citizens to question administrative decisions and thereby fostering the democratic principles of the nation by making the government accountable to its citizens. Thus, administrative law not only keeps a check on the government's functions but also upholds the rule of law, thereby promoting equality and justice. Slowly, as I would like to move towards the niche area I would like to highlight today, that is transgender rights. The most significant and initial moment of transgender rights in India was in 2014 when the Supreme Court of India gave its judgment in the Nalsa case. In this judgment, the Supreme Court gave majorly two directions. Firstly, that the state and the union governments both shall acknowledge the identity and individuality of transgender persons, and secondly, and most importantly, provide them reservation in SEBC category, that is, the socially and economically backward class. The most laudable outcome of this judgment was the enactment of the Transgender Persons Protection of Right Act 2019. This act very successfully includes most of the provisions relating to the protection and promotion of transgender rights, but very unfortunately remains silent on the aspects relating to reservation for transgender persons. We all shall agree to the fact that true inclusion is much beyond merely acknowledging the presence of transgender persons into the society. It is by facilitating their inclusion into the governance, by providing them employments in government sector or other sectors as well. Today in India, the transgender community forms a reasonable size as per the National Portal for Transgender Persons. The Ministry for Social Justice itself acknowledges and accedes to the fact that this portal has been visited for more than 22 lakh times, and over 12,000 transgender certificates and identity cards have been allotted across India. However, generally we are aware that both the central governments and state governments have provided positive discrimination for the upliftment of the downtrodden. For instances, the reservations that are provided to scheduled castes, scheduled tribes, etc. However, the absence of a statutory provision specifically to grant reservations to transgenders has definitely proven to be a hurdle in their societal acceptance. Aggrieved by the same, various applications were filed by the transgender persons themselves in the Maharashtra Administrative Tribunal, Principal Bench, Mumbai, which were clubbed together as Arya Pujari and others versus the state of Maharashtra and others, and heard together in 2022. Now, before understanding what were the observations made by the tribunal, let us understand the brief facts of this case. 2 out of the 3 applicants had applied for the post of police constables and the other to the post of talhati. The major prayers made by them were only to recognize third gender in the application forms, and secondly, provide these applicants reservation as transgenders. After hearing the submissions made from both these parties, the Principal Bench of Maharashtra Administrative Tribunal gave its interim order in November 2022, thereby directing the state to include a third option in gender as third gender in the recruitment processes held by them. These orders given by Maharashtra Administrative Tribunal were challenged by the state government in the Bombay High Court. The Bombay High Court also upheld the orders given by Maharashtra Administrative Tribunal and furthermore directed the state government to immediately form policies on this matter and give them effect prospectively. Now, as a result, consequently, on 3rd March 2023, a GR was issued by the state of Maharashtra wherein a third gender was included as an option in gender in the application forms of its recruitment processes. Now, the only issue remaining at hand is the aspect of providing transgender persons reservation in public employment in the state of Maharashtra. To understand the submissions made on behalf of the respondent, only 4 reasons were cited as to why the state is unable to provide this reservation. The first reason stated was that the Transgender Act of 2019 does not include any provision relating to reservation and therefore the state government is unable to do so. Secondly, emphasis was laid on the GR of 14th March 2022 wherein the state government has formulated a committee to analyze the directions given by the Supreme Court in the Nalsa Judgment 2014 as well as the various directions given by Maharashtra Administrative Tribunal over the time. A 14-member committee has been formulated, a report has been prepared after intensive research and the report is now pending towards the government for its approval. The third reason cited was that the state government follows the policy of the central government as far as reservation is considered. And as the central government does not provide any reservation to transgenders, the state government of Maharashtra is unable to do so. The fourth reason cited was that in this Indra Sawhney judgment, the Supreme Court itself had decided a cap of 50% as far as the reservation is considered. However, in the state of Maharashtra, vertical reservation, that is the reservation which is provided to backward classes such as OBCs, NTs, etc., has already exceeded 62%, and the horizontal reservation, that is the reservation provided to disadvantaged groups such as widows, orphans, etc., has exceeded 72%. And as a result of which, the state government of Maharashtra is unable to provide any further reservation. Moreover, the key submissions made on behalf of the applicant highlighted the fact that various other states such as Karnataka, Tamil Nadu, Jharkhand, Bihar and Chhattisgarh already provide reservation to transgenders. 1% reservation has been provided in the state of Maharashtra to transgenders in public employment, and other 4 states provide horizontal reservation to transgenders. Furthermore, it was also pointed out by the council appearing on behalf of the applicants that this state has rejected the plea for reservation on the basis that the central government does not provide reservation to transgenders, and as the state government strictly follows the reservation policy of central government is unable to do so. However, there have been various other instances where the state government has provided reservation even though the central government does not do so. For instance, the reservation that is provided to nomadic tribes in Maharashtra is a reservation which is not provided by the central government. The reservation that is provided to orphans in Maharashtra is also a reservation not provided by the central government. And most importantly, the 10% reservation that was previously provided to the Maratha community in Maharashtra was also a reservation not provided by the central government. Therefore, this excuse or reason given by the state government of Maharashtra stands extremely arbitrary. Nextly, what is also pointed out that the statistics given by the state government itself point out that the reservation cap of 50% given in Indus Rawani judgment has been exceeded long back. Yet reservations have been provided consecutively. Then only taking this reason to not provide further reservation to a transgender community, which actually requires upliftment in the modern days, and it's a community which is ridiculed, stands arbitrary and unacceptable. Now, as the submissions were advanced on from both the sides, various articles of the Constitution of India and other statutory provisions too were discussed and thrown light on. For instance, the Article 15 of the Constitution of India prohibits discrimination on the basis of religion, caste, sex or place of birth. Article 16 ensures that there is no discrimination and there is equal opportunities given in public employment. Furthermore, even the Transgender Act of 2019, Section 3, prohibits discrimination of any kind against transgenders. Section 8 of the Act secures and makes an obligation on the government to form policies to include the transgender community in the society. And Section 9 specifically states that transgenders are not to be discriminated in employment. Not only the Transgender Act of 2019 but also the Transgender Rules of 2020 give the similar stance. So, after analyzing the submissions made from both the sides and also the legal implications, the Division Bench of Maharashtra Administrative Tribunal Principal Bench Mumbai came to a conclusion wherein a judgment was passed by the Honorable Chairman, Retired Justice Mridula Bhatkar and Administrative Member Medha Ghadi that this judgment majorly consisted of two major directions. Firstly, that grace marks needed to be provided to transgenders so that they could reach the cutoff marks, or if these transgenders had already scored more than 50% of the total marks, they need to be considered for public employment. Secondly, if these transgenders crossed the age limitation and they had scored more than 45% in the marks in their previous examination, they were needed to be given an age concession. Thus, these were the guidelines or directions that the Maharashtra Administrative Tribunal came up, which would come to a midpoint where the cap of reservation, that is the 50% cap, too would not be exceeded, and the provisions too and the benefits too would be provided to the transgender community. In the state of Maharashtra, currently there are more than 5.5 lakh public employees, and yet there is not even one transgender who is the public employment in the state of Maharashtra. This absence itself highlights the fact that it's a time where the state of Maharashtra adopts a policy which is gender inclusive and gives them benefits by way of reservation into public employment. Thank you.
Swinal, thank you very much, because it was a very interesting topic, like transgenders, their employment, their reservations, and it was like a nice learning fun even for us to know the new laws regarding transgender. Thank you, the small token from Hammurabi team.